Good morning, good afternoon, or good evening, ladies and gentlemen, wherever you are. And welcome to SCMA's webinar, Halliburton against Chubb, Implications for International Maritime and Commercial Arbitration. For those of you who do not know me, I'm Lawrence Teh, Chair of the SCMA Promotion Committee. In 2019, SCMA saw that there was growing interest in the Halliburton case, not only in maritime and commercial arbitration, but also in international arbitration generally. Members of the audience may recall that a year ago, SCMA held a talk on the duty of disclosure by arbitrators, featuring Sir Bernard Eder, Christopher Smith QC, and Justice Anselmo Reyes, which focused around the English Court of Appeal's decision in Halliburton. So it was with great excitement that SCMA received news from Sir Bernard last month about the impending Supreme Court decision in the case, and SCMA went into action organizing the second Halliburton event, which you are watching now. The Supreme Court judgment is now available and has captured the imagination of everyone in arbitration. With us today is Sir Bernard, who many will know practiced as a barrister at Essex Court Chambers, specializing in commercial litigation and arbitration. Sir Bernard was an English High Court judge from 2011 to 2015, after which he was appointed an international judge of the Singapore International Commercial Court. He was formerly senior editor of Scruton on Charter Parties and formerly chair of the Insurance and Reinsurance Arbitration Society UK, whose report on treaty reinsurance arbitration was considered by the Supreme Court in the Halliburton case. Over the years, he's been appointed as arbitrator in over 300 international arbitrations and is now based at 24 Lincoln's Inn Fields. Sir Bernard will tell us about the Halliburton case. Also with us is Christopher Smith QC, a barrister practicing from Essex Court Chambers in London, specializing in wet and dry shipping. He's one of the editors of Scruton on Charter Parties and also Bills of Lading. He's a supporting member of the LMAA and an individual member of the SCMA. Chris was instructed on behalf of GAFTA, one of the intervening parties in the Supreme Court, and will address the maritime and commercial arbitration perspective of the case. And also with us is Charles Kimmins QC, a barrister at 20 Essex, with a broad commercial practice, including all aspects of shipping and commodities. He was nominated for International Arbitration Silk of the Year, 2019 and 2020 by Chambers and Partners and the Legal 500. He represented the LCIA, another intervener in the Halliburton case, and he will address the international arbitration perspectives of the case. You might notice that each of our speakers and myself have interesting visual backgrounds. At least for myself, they are courtesy of the arbitration facility Maxwell Chambers, where many SCMA arbitrations take place. I will now hand over proceedings to Sir Bernard, who will trace the relevant events and mention the highlights in the Supreme Court decision of Halliburton. Sir Bernard.
Good morning, good afternoon, good evening to everyone around the world. We are in London, or the speakers are in London, and a warm welcome to all of you. Could I have the first slide, please? I can't see it. Can I see it? There we are. Thank you. Well, this is a case, Halliburton and Chubb, that was heard in the Court of Appeal last year, and the judgment in the Supreme Court in London was delivered about 3 weeks ago, the end of November. My function today is to try to explain the general shape of the case and highlight a number of the main issues. The case arose out of an explosion on board a rig, the Deepwater Horizon drilling rig, in April 2010. Next slide, please. And out of this explosion, a number of arbitrations arose. If you look at this diagram, you will see that at the bottom in the middle, you will see that the rig was owned by a company called Transocean. It was leased to BP. and Halliburton, right at the top there, you'll see I put them, provided cementing and wall mounting services to BP. So as a result of this explosion, there were various third-party claimants. I've identified them, or I put them on the left-hand side, and they made claims against both Transocean and Halliburton. And both those sets of claims were eventually settled, with Halliburton paying some 1.1 billion US dollars and Transocean paying, by way of settlement, 212 million US dollars. They then, Halliburton and Transocean then brought insurance claims against their liability underwriters, and this gave rise to three main sets of proceedings. The first was between Halliburton and Chubb. I'll refer to that arbitration as Arbitration 1. It was in the Bermuda Form Liability Policy, and it provided that in the event that the parties did not agree to the identity of the chair, that the commercial court was to choose the chair, as I say, in the absence of agreement. So that's Arbitration 1. Separately, Transocean brought a claim also against Chubb under a different liability policy. We'll call that Arbitration 2. And there was also a separate claim brought by Transocean against another insurer in a separate arbitration, and that I will call Arbitration 3. Next slide, please. And I've tried to list here in this table the different steps in the arbitration, because the timing is very, very important. So in June 2015, Arbitration 1 kicked off. The parties were unable to agree on the identity of the chair. Chubb nominated a person who we now know as Mr. Ken Rokerson QC, a very well-known arbitrator in London. They proposed Mr. Rokerson. That was not agreed. It went before the court, but the court decided to appoint Mr. Rokerson as the chair in Arbitration 1. Thereafter, Arbitration 2 kicked off, and in December 2015, Chubb then nominated Mr. Rokerson as its appointed arbitrator. Mr. Rokerson disclosed to Transocean in his arbitration as chair in Chair 1, as chair in Arbitration 1, but he did not disclose to Halliburton in Arbitration 1 his proposed appointment in this Arbitration 2. In Arbitration 2, Transocean did not object to the appointment of Mr. Rokerson, and then Mr. Rokerson accepted the appointment in Arbitration 2. Then about 9 months later, Arbitration 3 kicked off, and Mr. Rokerson accepted a joint nomination, as substitute arbitrator, but he did not disclose that appointment to Halliburton in Arbitration 1. A few months later, in November 2016, Halliburton then discovered the appointment of Mr. Rokerson in Arbitrations 2 and 3. And Halliburton expressed concern, and there was correspondence, and they asked Mr. Rokerson for an explanation. At about the same time, there was a hearing of the preliminary issue of policy construction in Arbitration 2 and also in Arbitration number 3. Next slide, please. We're now at the end of December of 2016. Mr. Rokerson responds to the request for an explanation from Halliburton. He says that he appreciated, with the benefit of hindsight, that it would have been prudent for him to have informed Halliburton through its lawyers and apologized for not having done so, but he maintains that he's independent, but nevertheless offers to resign. But Chubb refused to agree his resignation. As a result of that, Halliburton decided to issue proceedings in the commercial court, that is an application to remove Mr. Rokerson under Section 24 of the Arbitration Act 1996. The hearing of that application took place a little later in January 2017. And then shortly thereafter, but before the judgment in the hearing in that application, there was a hearing of the preliminary issues of construction in Arbitration 1. Shortly after that, in early February 2016, Mr. Justice Popplewell gives judgment and dismisses the Section 24 application by Halliburton and refuses to remove Mr. Rokerson. Shortly thereafter, in early March, you will see that there was then an award in both Arbitration 2 and Arbitration 3 on the preliminary issues, in both cases finding in favour of Chubb. Thereafter, after some delay, the Arbitral Tribunal in Arbitration 1, including Mr. Rokerson as chair, of course, issues its award, again in favour of Chubb. Meanwhile, Halliburton have launched an appeal to the Court of Appeal, seeking to reverse the decision of Mr. Justice Popplewell in the Section 24 application. But in April 2018, the Court of Appeal dismisses that appeal. It then goes to the Supreme Court, and then the Supreme Court, as I have said a few weeks ago, dismisses that appeal, and that is why we are here today. Next slide, please. So very briefly, I'm not going to spend much time about what the Court of Appeal said. It is important. But in summary, the Court of Appeal held that Mr. Rokerson ought to have disclosed his appointment in Arbitration 2 and Arbitration 3 to Halliburton in Arbitration 1, but came to the conclusion that mere non-disclosure was not, without more, sufficient to give rise to an inference of apparent bias, and that, in a nutshell, is the basis of the refusal of the appeal in that case. Next slide, please. Now, in the Supreme Court, there is a long discussion about various important matters concerning the duty to disclose, the duty of confidentiality. I'm only going to highlight a number of those issues, and then the actual decision in that case, the reasons for the decision in that case for refusing the appeal are set out very shortly at the very end, and I'll summarize those in a moment. But at paragraphs, highlight number 1 relates to the duty to disclose. So at paragraphs 49 to 69, the Supreme Court considers the arbitrator's duty of impartiality and concludes that in addressing an allegation of apparent bias in an English-seated arbitration, the English courts will, 1, apply the objective test of the fair-minded and informed observer, and 2, have regard to the particular characteristics of international arbitration. And that conclusion is summarized in paragraph 69. The important part of that there is the reference to the objective test of the fair-minded and informed observer. And no doubt Chris Smith and Charlie Kimmins will discuss that in due course. Next slide, please. Highlight number 2 is important. It covers a number of paragraphs from 70 to 116, but the conclusion at the end at 116 is that there is a legal duty of disclosure on arbitrators, which imposes an objective test. And I think that is important. I think that is perhaps the first case, I'm not sure, in the world that has decided that arbitrators have a legal duty of disclosure. Right, next slide, please. Here there is an important section dealing with multiple references. So that is a situation where an arbitrator accepts appointments in multiple references concerning the same or overlapping subject matter with only one common party. And then you'll see what it said, which is, again, important. It says this may, and you might like to highlight the word may, but this may, depending on the relevant custom and practice, give rise to an appearance of bias. And so that is concerned with the duty of disclosure in the context of multiple references. Next slide, please. So there is much in the Supreme Court judgment that deals with the reference to custom and practice. And in the Supreme Court, the court heard submissions on behalf of GAFTA, the LMAA, the LCIA, the ICC, as to the different practices in the different types of arbitration. And here I've selected for highlight number 4 what the Supreme Court has said with regard to GAFTA and LMAA. And he says, as GAFTA and LMAA have shown, it is an accepted feature of their arbitrations that arbitrators will act in multiple arbitrations, often arising out of the same events. Parties which refer their disputes to their arbitrations are taken to accede to this practice and to accept that such involvement by their arbitrators not call into question their fairness or impartiality. In the absence of a requirement of disclosure of such multiple arbitrations, the question of the relationship between such disclosure and the duty of privacy and confidentiality does not arise. As I have said, there is evidence of similar practice in reinsurance arbitrations. So you will see there that the observations are by reference to GAFTA and LMAA. One of the important questions that I know Chris Smith will speak about briefly is the extent to which that practice in the LMAA does or does not apply, perhaps, to the SCMA. And certainly, I think we would be keen to hear from practitioners in Singapore as to their views with regard to that. Next slide, please. Here again, in paragraph 136, the question of the nature of the legal duty arises. As I have said, certainly the Supreme Court has said that there is a legal duty of disclosure, but the question is, well, what's the nature of that duty? And here in paragraph 136, the Supreme Court says that unless the parties to the arbitration otherwise agree, arbitrators have a legal duty to make disclosure of facts and circumstances which would or might reasonably give rise to the appearance of bias. The fact that an arbitrator has accepted appointments in multiple references concerning the same or overlapping subject matter with only one common party is a matter which may have to be disclosed depending upon the customs and practice in the relevant field. In the cases in which disclosure is called for, the acceptance of these appointments and the failure by the arbitrator to disclose the appointments taken in combination might well give rise to the appearance of bias. Well, again, you will see the important words are which may have to be disclosed depending on the customs and practice in the relevant field. And the last line in combination might well give rise to the appearance of bias. So you can see that there is no clear statement, and perhaps that is necessarily the nature of things. Next slide, please. The decision. So at the very end of the judgment, I think there are 4 paragraphs, 145 to 148, dealing with the decision in the case. And the decision, you'll see, it says that Mr. Rokerson was under a legal duty to disclose an appointment in arbitration to Halliburton because at the time of that appointment, the existence of potentially overlapping arbitrations with only one common party was a circumstance which might reasonably give rise to the real possibility of bias. And then Mr. Rokerson's failure to make that disclosure was a breach of his legal duty of disclosure that may well have satisfied the real possibility of bias test. So the conclusion there was that Mr. Roken had breached his duty, and that breach may well have satisfied the real possibility of test. However, and the important word is however here, by the time of the Section 24 hearing, Mr. Rokerson had explained his oversight, accepted by Halliburton as genuine, and furthermore, the reference in arbitration 2 came 6 months after the reference in arbitration number 1. It was more likely that Transocean would have cause for concern rather than Halliburton. Next slide, please. So on the facts, the Supreme Court was not persuaded that the fair-minded and informed observer would infer a real possibility of unconscious bias on the part of Mr. Rokerson for 5 main reasons. And these are the 5 main reasons given by the Supreme Court, which support the conclusion stated by the Supreme Court that although Mr. Rokerson had breached his duty, nevertheless, the Section 24 application would be dismissed. And here are the 5 reasons. The lack of clarity in English case law as to whether there was a legal duty of disclosure and whether disclosure was needed. That was at the time of the hearing before the court. Secondly, the time sequence of the 3 references. 3, Mr. Rokerson's measured response to the challenge. 4, no question of Mr. Rokerson having received any secret financial benefit, and 5, no suggestion of an unconscious bias in the form of subconscious ill will in response to the robustness of the challenge. Now, it is fair to say that since the delivery of the judgment in the Supreme Court, there has been much debate, and there have already been many webinars in London focusing on the decision, focusing on the judgment, and in particular the decision, and in particular the 5 reasons given that I've summarized here for deciding that the appeal should be dismissed. And it's also fair to say that there has been much criticism of at least this part of the judgment and the crucial part, that is the decision of the Supreme Court, effectively upholding the decision of the courts below, refusing the Section 24 application. Perhaps we can discuss that, and perhaps Chris and Charles may discuss it as well. But that is all I wanted to say. Thank you for listening, and I will now pass on the baton to Chris Smith. Thank you.
Thank you. Now, over to Chris Smith, who will tell us and speak to us about the commercial and maritime perspective in the Halliburton case. Chris? Chris, you're on mute.
Thank you. Thank you very much, Lawrence. Thank you, Sir Bernard. Good afternoon, good morning, good evening to everyone around the world. I'm going to address the maritime and commodities perspective. Before I do so, I should put in a little disclaimer. Although, as Lawrence has said, I was instructed on behalf of GAFTA in their intervention in the Supreme Court, for today's purposes, the views I'm going to express are entirely my own. They don't represent the views of GAFTA or the views of the LMAA, the other intervener in the Supreme Court, from the commodities and maritime perspective. By way of overview, what I'm going to do is to touch briefly on what makes maritime and commodities arbitrations different, why then the Supreme Court of Appeal decision caused concern, and finally, has the decision of the Supreme Court resolved those concerns? Next slide, please. Now, just to recap, to put those matters into perspective, the issue referred to the Court of Appeal was whether and to what extent an arbitrator may accept appointments in multiple references concerning giving rise to an appearance of bias, and whether and to what extent he may do so without disclosure. Those are set out in paragraph 2 of the Court of Appeal judgment. And in deciding those issues, the Court of Appeal touched on the duty of disclosure generally, obviously, and it specifically considered also the question of whether repeat appointments by the same party, but not necessarily involving the same facts or related facts, could give rise to justifiable doubts about the impartiality of the arbitrator. And significantly, it's recorded at paragraph 90 of the judgment that counsel for Chubb accepted that 10 appointments for one party might give rise to justifiable doubts, although the judgment doesn't actually record over what period those 10 appointments would have to be. And in the course of considering the issues that arose, the Court of Appeal referred to the IBA guidelines on conflicts of interest, the ICC rules, and the LCIA rules. And at paragraph 67, it concluded that in the context of international commercial arbitration, as a matter of good practice, disclosure of multiple appointments ought to have been given. And that was at paragraph 89 of the judgment. It also referred to what it described as best practice in international commercial arbitration. And that was at paragraph 91, but without any, or at least any apparent regard for the possibility that different considerations may be relevant in different types of arbitration, or specifically to the practice in maritime and commodities arbitrations. The Court of Appeal concluded that M, as he was then known, Mr. Rokerson QC, as we now know, ought as a matter of law to have disclosed the multiple appointments, but without giving any indication as to how that legal duty might apply to other forms of arbitration, or to the relationship between issues of disclosure and issues of confidentiality. Next slide, please. Thank you. So moving on to look at the issues that arise in maritime and commodities arbitrations. Firstly, chains of contracts and subcontracts are commonplace, particularly charter party chains, some of which may or may not be on back-to-back terms, for example, time charters and sub-time charters, but also chains of charter parties that are clearly not on back-to-back terms, a bareboat charter followed by a time charter followed by a voyage charter, for example. Another example of chains of contracts in the maritime field is sales or sub-sales of second-hand tonnage, or sales and then resales of new build tonnage. And all of these give rise to the possibility of multiple appointments. And it is common in maritime arbitration for the same arbitrator to be appointed up and down the line. In fact, I've done cases where when one party declined to appoint the same arbitrator up and down the line, all the other parties positively complained about that because that was perceived as being a delaying tactic. And in commodities arbitrations, pretty much the same position applies. So you have string sales of sale contracts and then sub-sales and sub-sub-sales. And those are specifically provided for in the GAFTA rules. And in both shipping and commodities arbitrations, it is common also to have a single event which may give rise to multiple arbitrations, sometimes between the same parties, but often between entirely different parties. So a strike at a load port that affects a number of different sale contracts, delays in the construction of a series of new build vessels that affect a number of different buyers, or a casualty involving one vessel but multiple consignments of cargo on board, in which the same arbitrator may well be appointed. And as I said, in maritime and commercial arbitrations, it is common for the same arbitrator to be appointed up and down the line, or in relation to more than one reference. And this may well, of course, lead to some arbitrators accepting and receiving more than 10 arbitrations in even 1 year. That's cutting through the number suggested by Chubb and cutting way through the number that is suggested in the IBA orange list. And all of this, it was submitted to the Supreme Court in due course, was done or is often done without anybody giving disclosure either up or down the line. And given the relatively small pool of arbitrators available and the large number of disputes arising, it's also common for the same arbitrator to be appointed by the same party, but not only by the same party, sometimes by, for example, parties with a common manager in terms of different shipping companies, or parties with a common P&I club or hull insurer, or parties represented by the same law firm. Indeed, there are also many members of the bar who practice as members of the shipping bar, but accept appointments at arbitrators. And that gives rise to the question of whether they have to give disclosure if they're appointed by a law firm for who they also accept instructions as counsel. And all of these practical issues that I've tried to highlight are compounded by the fact that in maritime arbitrations, the appointments and the instructions tend to be by a relatively small group of very specialized shipping lawyers who have the relevant knowledge and expertise. And that compounds the issue about disclosure. So next slide, please. And is essentially all of that gives rise, in the light of the Court of Appeal discussion, to the following issue, in my view. Is there anything inherently wrong with multiple appointments, either in references concerning the same or overlapping subject matter, or in references where the appointment is by or on behalf of the same party? At the very least, by basing its judgment on what it considered to be, as I've said, best international practice in commercial arbitration, and by proceeding on the basis that accepting multiple appointments may give rise to an appearance of bias, the Court of Appeal judgment, in one sense, effectively proceeded on the basis that objectively viewed there is something inherently wrong with accepting multiple appointments. The Court of Appeal also appeared to give no consideration or no detailed consideration to the interrelationship between the duty of disclosure and the confidential nature of arbitration. Disclosure and a duty to disclose is all very well, but what can an arbitrator disclose without breaching his obligations of confidentiality? And the Court of Appeal judgment really seems to take no account of the practical difficulties that can arise, particularly in maritime arbitrations, when appointments are often made right at the end of the limitation period, and you'll all be familiar with the short limitation periods that apply in maritime matters. And often in relation to just for the purposes of protecting time, in which case the arbitration never proceeds, but it still counts towards the arbitrator's tally for the purposes of the IBA Orange List, if that applies. And also, it didn't take into account the particular difficulty I touched on a moment ago, particularly in maritime arbitrations, of identifying precisely who the relevant party is. So if as an arbitrator you are considering whether or not you've been retained or appointed in a number of different references by the same party, do you just look at the SPV, the single ship-owning company that has appointed you? Or do you try and find out who the beneficial owners of the SPV are? Or do you look at who the managers of the ship-owning company are? Or perhaps who the H&M insurers or the PNI club are involved? So it's against that background of concerns arising from the Court of Appeal judgment that GAFTA and the LMAA applied for permission to intervene, so as to ensure that the Supreme Court was aware of the practice in shipping and commodities arbitrations and the practices that made them different, to support the argument that the test for apparent bias was objective, not subjective. There was a suggestion that at least one of the other interveners was going to argue for a subjective test rather than an objective test. And also so as to ensure that any test for disclosure formulated by the Supreme Court took into account all of the factors. And it's important to stress that neither the LMAA nor GAFTA sought to argue that there was no duty of disclosure, but SICC, and also that the mere fact of appointment in overlapping references does not of itself give rise to an appearance of bias. Next slide, please. Now, the Supreme Court judgment goes a long way towards meeting the concerns expressed by GAFTA and the LMAA. Specifically at paragraph 43, the position of GAFTA was recognised that disputes in relation to string contracts are regularly referred to the same arbitrators, and the position of the LMAA was referred to at paragraph 44. Multiple appointments are relatively common. And as Sir Bernard says, the Supreme Court decision is that there is a legal obligation to give disclosure, and that it can be engaged even where the facts are only those which may lead an objective observer to conclude that there's an appearance of bias, not that there definitely is an appearance of bias. That's the test for disclosure. But the Supreme Court specifically recognised that in shipping and commodities arbitrations, multiple appointments are commonplace and do not necessarily call into question the arbitrator's impartiality. Next slide, please. And so at paragraph 87 of the judgment, next slide, thank you. Yes, so paragraph, next slide, actually, we've missed one out, next slide. At paragraph 87 of the judgment, no, it's gone backwards. One more, thank you. There are practices in maritime sports and commodities arbitrations in which engagement in multiple overlapping appointments does not need to be disclosed, because it is not generally perceived as calling into question the arbitrator's impartiality. Next slide, please. Thank you, yes. And then at paragraph 135, there may also be circumstances in which, because the custom and practice of specialist arbitrators in specific fields, such as maritime sports and commodities, and maybe others, such multiple appointments are part of the process, which is known to and accepted by participants. In such circumstances, no duty would arise. And then next slide, please, paragraph 91, which Sir Bernard already referred to in his slide pack. GAFTA and LMA have shown it's an accepted feature of their arbitrations that arbitrators will act in multiple appointments, often arising out of the same events. Parties which refer to their disputes to these arbitrators are taken to accede to this practice and to accept that such involvement by their arbitrators does not call into question their fairness or impartiality. Now, this reflects, but goes a little bit further than paragraph 3.1.3 of the IBA Orange List, because the carve out there only applies to multiple appointments by the same party, whereas the carve out effectively that the Supreme Court has now recognised relates to multiple appointments in related references. Now, specifically, as well as looking at these issues, the decision in the Supreme Court recognises that confidentiality trumps disclosure. The information that can be disclosed in multiple cases, multiple references, is limited. It includes, firstly, the identity of the common party. Secondly, whether the proposed new appointment is by the common party as an appointing party or by the common party nominating the arbitrator for appointment by a court or third party. And thirdly, a simple statement of the fact that the second reference arises out of the same incident. That's paragraph 146. Supreme Court essentially also said that if the arbitrator needs to give additional information in order to fulfill his duty of disclosure, he must either obtain consent or decline the appointment. That's paragraph 101. And so, although this clarification, both in relation to disclosure and in relation to confidentiality, is welcome, I have two concerns that I'd like to just touch on today. Next slide, please. The first concern is that the general position, a little bit like in the Court of Appeal, is now clearly that acceptance of multiple appointments may give rise to an appearance of bias, and so that there must, as a matter of law, be disclosure in the absence of a contrary agreement. I'm concerned the Supreme Court decision risks giving the impression that maritime commodities arbitration is somehow second best, and that would be a proposition I fundamentally disagreed with. But specifically, one of the arguments before the Supreme Court was that English law had set a gold standard, which would encourage parties to arbitrate in London. The Supreme Court has attempted to do so by making it clear that there is a legal duty of disclosure and that appointments in multiple references must be disclosed, particularly in a Bermuda form case. The test is objective, as I've said, but it can arise even where the matter to be disclosed falls short of something that would in fact substantiate apparent bias. Now, Charlie Kimmins will later on deal with the question of whether the Supreme Court has satisfied the wider arbitration community, but by setting a gold standard and specifically recognising a carve-out for maritime arbitrations, my concern is, has the Supreme Court effectively made it look as if maritime arbitrations and commodities arbitrations accept a lower standard of fairness? And in my view, that would not be correct. Second point, which I think I'm going to have to canter over fairly quickly, is that I remain puzzled about precisely how, as a matter of analysis, the carve-out works. The Supreme Court's approach is that there is effectively an established practice in maritime and commodities arbitrations, meaning that engagement in multiple and overlapping arbitrations does not need to be disclosed. That's paragraph 87. The argument is that it's an accepted practice of LMA and GAFTA arbitrations that arbitrators will accept multiple appointments. It's therefore said that parties that refer their disputes to LMA and GAFTA arbitration accept the involvement of multiple arbitrators in multiple references. But does that really work in practice? Next slide, please. And that gives rise, in my view, to the following questions. Firstly, are all users of maritime and commercial commodity arbitrations really aware of this practice that the Supreme Court has held to exist? Do all users of maritime and commodity arbitration agree with or consent to the practice? Could users of maritime and commodities arbitration try and opt out of the practice? Could they still require what I've called the gold standard? And could a party argue that, notwithstanding what the Supreme Court has held, there is in fact no settled custom and practice, and no custom and practice that affects them, such that they can still insist on disclosure? And particularly, as Sir Bernard said, how does that work in the context of an SCMA arbitration? There's still an international shipping arbitration. It still involves many of the same parties, many of the same clubs and insurers, owners and charterers would refer their disputes to Singapore arbitration as to London arbitration. So if there is a practice, presumably they're all aware of it and accede to it, but does apply if they refer their references or their disputes to Singapore arbitration as opposed to London arbitration. And the same difficulty actually arises in relation to disclosure. because the Supreme Court has held that the high level of disclosure I mentioned can be given without breaching any obligation of confidentiality, because the consent of the party, common to both references, can be inferred. But again, I'm not entirely sure that's correct, because if one looks at the facts of the Halliburton case, how would it work if, for example, it had been Transocean that had sought to appoint Mr. Rokerson QC? So if Transocean had appointed him in the second reference, it couldn't be said that Chubb had consented to disclosing the first arbitration to the parties to the second arbitration, and because it's not the appointing party. And it couldn't, or certainly couldn't necessarily be said, that Transocean had consented to disclosing the second arbitration to the parties to the first arbitration, about which it knows nothing. So I'm not entirely convinced that the concept of consent or accepting an accepted practice is the right answer. And if one looks, for example, at Rule 42 of the SCMA rules, the tribunal is expressly required to keep all matters, including the existence of the arbitration, confidential. So next slide, please. The Supreme Court suggested, paragraph 135 of the judgment, that rather than having a dispute about whether the settled practice exists or not, it may be wise for arbitral bodies, presumably it meant by that the LMAA or GAFTA, to put the existence of an accepted practice beyond doubt by writing something into their rules. So I've quoted paragraph 135 there on that slide. But does that work? Take, for example, the holder of a bill of lading in a maritime context, who's only bound by arbitration because the charter party, which he's never seen, refers to arbitration, which he is then bound by. Can he be taken to have contracted out of the right to disclosure that would otherwise exist in an international arbitration? I think that's an issue that we're going to need to think about. On the logic of the Supreme Court decision, is it actually necessary to include an express statement in the rules? If there's an established practice which the objective observer would take into account, does it need to be written down? And would any organisation actually want to write into its rules an obligation, a confirmation that disclosure doesn't need to be given in these circumstances? Next slide, please. So as I said, does it work to amend the rules? Is it necessary? Is it desirable? And just to illustrate that, I've put up here the SCMA rules. A prospective arbitrator shall disclose to any party who approaches him any connection with his possible appointment, any circumstances likely to give rise to justifiable doubts. And that obligation is ongoing. An arbitrator once nominated or appointed shall disclose any such circumstances, as referred to in 15.2 to all the parties. But Rule 44, the tribunal shall at all times treat all matters relating to the arbitration, including the existence of the arbitration, as confidential. So does that require an arbitrator to disclose multiple appointments? And does the confidentiality obligation even permit the arbitrator to disclose the multiple appointments? Now, in my view, it's important to remember that all participants in arbitration want their dispute to be resolved fairly and in an impartial manner. In my view, ship owners, charterers, commodity traders do not have lower standards when it comes to justice and partiality. They may want speed and efficiency, but that's true of everyone that arbitrates. They may want tribunals that are well versed in subject matter, but not at the expense of being partial. So why should the practice in shipping and arbitration, commodity arbitrations, be different? And when thinking about how the Supreme Court test works in practice, in my view, it's useful to ask ourselves, what is the basis of the established custom and practice? And there are three possibilities, I think. The first is that it's just because in shipping and commodities, we're all much more used to string contracts, chain disputes and such like. They're much more common, so we're just more used to them and less worried about them. Second possibility, as a supporting member of the LMAA and an individual member of the SCMA, of course, it's tempting to say that those involved in shipping and commodities arbitrations as arbitrators are simply better at putting matters out of mind and deciding matters impartially. But I don't think really the identity of the arbitrator can be the deciding factor, because otherwise when Mr. Rokerson sat as an LMA arbitrator, he would not have to give disclosure, but when he sat in a Bermuda form arbitration, he would. So in conclusion, I suspect it's simply this, that those involved in shipping and commodity disputes have a greater degree of trust in those who offer their services as arbitrators, and that the accepted feature of maritime and commercial arbitrators, commodity arbitrations, reflects this trust, which has now been recognised by the Supreme Court as giving rise to an established custom and practice, and that's paragraph 137. So I hope I've thrown out a few interesting questions. I think I've run over time, for which I apologise, and I hand over to Charlie.
Thank you very much, Chris, and before that, Sir Bernard. You've heard the perspective of the maritime and commercial arbitration community. Now I give you Charlie Kimmins, who will talk about the perspective of the international arbitration community. Charlie.
Thank you, Lawrence. So I have the rather difficult task, frankly, of considering the case from the perspective of everybody else. So I'm going to consider it from the perspective of the international arbitral community who engage in London arbitration other than the maritime and trade communities. So I'm going to look at it from the perspective of the likes of the LCIA, the ICC, CARB, Bermuda form users, ad hoc users. And for convenience, I'm going to refer to that community compendiously as the wider arbitral community. And I should say at the outset, similar to Chris, that the views I'm going to give are my views, not those of the LCIA, who I represented at the hearing, or indeed any other section of the wider arbitral community. So the first slide you can see up on your screens now that refers to the Court of Appeal decision and asks the question, why did it cause ripples in the wider arbitral community? Because it certainly did. There were a number of articles which complained that the decision was not sufficiently robust. In fact, there was one particular article which was cited repeatedly to the Supreme Court, an article by some US attorneys who said that if the law remained as it did in the CA, in the Court of Appeal, that firm would recommend to all clients not to agree to ad hoc London-seated arbitrations. Now, it's fair to say as well that that type of reaction was different to the reaction of much of the maritime and trade communities and the likes of LMAA and GAFTA. So the first point I want to consider is why was the reaction so different? Why did you have what appeared to be two camps, the international LCIA ICC type camp and the GAFTA LMAA type camp? Well, it seems to me that there were four reasons for this. The first is that the needs and expectations of those different arbitral communities differ. And that key point was recognized by the Supreme Court. So starting with the London maritime and trade arbitrations, what do the users want? They want speed and efficiency. They also would recognize that a single set of facts can often give rise to a great number of related claims. That's a point that Chris touched upon, whether it's under subcharters, sale and purchase agreements, and all the rest of it. Thirdly, that London trade and commodities arbitration community wants arbitrators who are well versed in the specific type of issues that regularly arise in those arbitrations. Sometimes they involve very difficult and specialist issues, which wouldn't mean much to a general commercial practitioner. And as a consequence, the pool of arbitrators is relatively limited. Now, where does all that go? Well, the net result is that in those types of arbitrations, multiple appointments with overlapping issues and one common party are relatively commonplace. And indeed, the distinction between the two types of arbitration was recognized long ago in the IBA guidelines. Now, turn it on its head and consider it from the perspective of the wider arbitral community. Now, they, of course, will be involved in arbitrations involving a wide array of disputes arising under all types of contractual documents. There is perhaps less of a premium on speed because you don't have those tight one-year time limits. And the arbitrations are fewer in number, significantly fewer in number, but sometimes higher value. And the net result, again, is that such arbitrations such as those, there are less likely to be multiple appointments with overlapping issues and one common party. It's more unusual. So the second reason why perhaps they saw things so differently is because those different needs and expectations resulted in the procedures being a little different. So under many of the institutional rules, you have much more emphasis on disclosure. When you want to accept an appointment as an arbitrator, under many of those rules, you have to fill in a form. And that form says, please identify any particular issues that you feel you ought to disclose. And of course, you don't get that type of form in the London LMAA type arbitrations. Under many of the institutional rules, there are bespoke rules which oblige an arbitrator to make disclosure. And under many institutional rules, there are bespoke provisions for challenging arbitrations before the institution itself. Now, going back to trade and maritime arbitrations, it's difficult to generalize, but you often don't see any of those characteristics. And instead, you have characteristics, procedural characteristics, which are very different. For example, the rules positively encourage multiple appointments on overlapping issues under some rules. Hence, the LMAA permits a tribunal to order concurrent hearings without the agreement of the parties. So those are two reasons why it seemed to me that we had what appeared to be something of a clash between the two different camps. A third reason is this, that there appeared to me to be some concerns in the wider arbitral community that too much emphasis was given by the English courts to the reputation of the individual arbitrators concerned. So whenever there was a challenge, if the arbitrator had an excellent reputation, which so many do, that would have become a relevant factor. And the international arbitral community queried that. And for some of them, it seemed particularly peculiar for the courts to rely on the reputation of an arbitrator when the identity of that very arbitrator remained concealed, which of course it did right up until the Supreme Court. And so I got the impression that in the wider arbitral community, there was a feeling amongst some that London arbitration was somewhat collegiate. That, of course, was not the case for the maritime and trade communities, where the close-knit community was seen as an advantage, not something to fear. One final point, trying to drill down why you had these different views from different camps, is this, that in institutional arbitrations such as those under ICC and LCIA rules, there is no right of an appeal on an issue of law. And if there is no right of appeal, the parties understandably feel more exposed to the danger of an impartial tribunal. Under London maritime and trade arbitrations, of course, if the tribunal makes an error of law, you can appeal under Section 69. Under LCIA and ICC rules, you can't. And therefore, there was a feeling that lack of accountability might breed partiality. Finally, and just by way of observation, I got the impression that the wider arbitral community was just generally concerned that the Court of Appeal judgment wasn't sending the right message. They wanted to get they wanted the message to come across that English law took disclosure seriously. They were concerned that whilst the Court of Appeal had confirmed there was a duty to give disclosure, the duty was somewhat toothless and without sanction. So they wanted the principles to be more robust. So next slide, please. Hence, we had multiple interventions. So everybody stuck their hand up and said, we have something to say, we have an interest in this, and served written submissions before the court. Now, ironically, once all those submissions came in, the net result was that at heart, there was much less between the different camps than everybody thought. And that was because both the maritime and the trade institutions and the wider arbitral community all submitted that the issue of apparent bias and disclosure was very fact and context sensitive. So to everybody's surprise, you didn't see the wider arbitral community saying that the maritime interveners had got it wrong, and vice versa. Everyone seemed to be much on the same page. There were, though, a few differences. Some of the interveners submitted, for example, that there was no legal duty to disclose, whereas the institutions, such as the LCIA, who I represented, argued that there was such a duty. And one of the reasons that the LCIA took that point is they wanted the message to be sent to the arbitral community to be a robust and strong message. So next slide, please. So what did that wider arbitral community submit to the Supreme Court? Well, essentially they submitted as follows, that first of all, the application for the test for apparent bias depended heavily on the context. Now, that may not sound surprising, but it's obviously right, frankly, that it must depend heavily on that particular context. Secondly, they submitted that accepting appointments in multiple references with overlapping issues could, and I emphasize could, not would, could give rise to an appearance of bias. Again, it all depended on the facts. Now, they also submitted, and I found this to be particularly interesting, that in applying that test for apparent bias, reputation should be of little or no relevance. And that was a submission which was ultimately accepted by the court. They also submitted, and again, this is an interesting point, that the standard expected of the chairperson and of the tribunal must be, the chairperson of the tribunal must be the same standard as that expected of party appointed arbitrators. You couldn't distinguish between the two and say that one group were to be held to a higher standard than the other. Then moving on to disclosure, the wider arbitral community said there must be a legal duty and that the duty was to disclose facts and matters which would or might, and again, I emphasize those words, would or might give rise to an appearance of bias. The next point, which funnily enough wasn't accepted, was this. The wider community submitted that the fact that a non-disclosure was innocent was of limited relevance. And that was because it's so difficult to prove otherwise. But you'll note that the Supreme Court, in making their decision on the facts, did take into account the fact that the non-disclosure was innocent. And finally, it was submitted that a non-disclosure could itself tip the balance, leading to a finding of apparent bias. So that's what was submitted by the wider arbitral community. Next slide, please. Is the wider arbitral community happy with the Supreme Court judgment? Well, I should say at the outset, that's an almost impossible question to answer, as anybody will see from reading the great variety of articles which have emerged on the web and elsewhere, all saying slightly different things. But if I try and draw together some of those threads, I come out roughly here. First, I think the wider arbitral community will welcome the clarification of the law in certain particular respects. I think they will welcome the fact that the court recognized that accepting multiple appointments with overlapping issues and one common party can give rise to an appearance of bias. Just to be clear as to why that is, the underlying rationale is that one party in those circumstances can have access to what became known as inside information, or they may have the ability to have a dress rehearsal. These are the phrases that you saw banded around in the Supreme Court. Secondly, I think the arbitral community will welcome the fact that reputation was found to be of limited relevance. I think they'll also welcome the fact that arbitrators must disclose facts and circumstances which would or might, and again I emphasize those words, would or might give rise to justifiable doubts as to impartiality, and will also welcome the recognition of a legal duty to disclose. Just by way of an aside, for my part, I sometimes find it quite difficult to understand what is the basis of that legal duty, the jurisprudential basis. When one looks at the Supreme Court judgment, it's not entirely clear. But nevertheless, there is a duty, and that's good news. It sends the right message. The next point is this. I don't think the wider arbitral community will envisage that the particular judgment will result in rafts of unmeritorious challenges. I think the Supreme Court made it plain that the response to the challenges should be robust. So I don't see there being a real floodgates problem. But finally, there do remain some concerns emerging from the Supreme Court judgment. Some principles will be difficult to apply. Some questions remain unanswered. And some people, it's fair to say, have questioned the result on the facts. Just unpicking those a little bit, what principles might be difficult to apply? Well, Bernard and Chris have already touched on this, but how easy will it be to work out if the custom and practice of a particular type of arbitration is such that there is a legal duty to disclose multiple appointments with overlapping issues in one common party? Disclosure is not required in NMAA or GAFTA, not required in some reinsurance arbitrations, is required in Bermuda form or ad hoc. And this is all because of what is seen to be the relevant custom and practice. But that's not easy to unpick. How do you determine what your practice and custom is? And how easy will it be to work out if the custom and practice of a particular type of arbitration is such that there is deemed to be implied consent to an arbitrator disclosing confidential information? So again, that's a very difficult question. Now, as for the unanswered questions, I'll deal with that very quickly. There are one or two which I find, frankly, personally fascinating. One of those is this: are arbitrators under an obligation to exercise due diligence to check for material which might give rise to an appearance of bias? Difficult question, left open by the Supreme Court. What is the sanction on arbitrators for breach of the duty to disclose? Again, not easy to find the answer to that in the judgment. And finally, are party-appointed arbitrators to be given any more latitude than the chair? Again, something I touched on earlier. So those are three particularly interesting, in my view, unanswered questions in relation to which we will have to watch this space. But there we go. That's my canter through the Supreme Court's judgment from the perspective of the wider arbitral community. And I'll now hand back to Lawrence, who I think is going to deal with Q&A.
Thanks, Charles. We've come to the question and answer section of this event. Without my prompting, a whole raft of questions have come in, but I should say that if you have a question that you'd like to submit for selection, please submit it using the chat function, not the Q&A function. In the meantime, may I start by asking the panelists a question that I prepared, and this has to do with custom and practice, for which we've received a lot of questions as well. And the question goes like this: disclosure by an arbitrator of an appointment or possible appointment in a related arbitration based on express consent of the parties to the other arbitration is easy enough. How does an arbitrator know if an arbitration agreement carries a term implied from, quote, the custom and practice in the relevant field of arbitration, unquote, that the parties in the other arbitration consent to disclosure? Do the customs and practices in London commercial and maritime arbitration come through to Singapore and come through to SCMA arbitrations? And I thought I would lead with this question because many questions have been received asking about how this test of custom and practice applies. Can I ask Sir Bernard to lead us off with some quick comments, followed by Chris, and then followed by Charles? Bernard, you're on mute.
Yes, sorry. My answer is, I'm going to fudge the answer in a way, Lawrence, in the sense that if the Supreme Court is right, and one of the questions, I suppose, is whether the Supreme Court judgment or any part of it applies in Singapore. The Supreme Court judgment in England deals with the matter as a matter of English law. So there's an initial question as to whether it applies. And there are a number of recent judgments in Singapore which do not follow English law. And therefore, that's an initial question, I suppose. The second question then, if it does apply, then there's a separate question, whether or not in the way that you put the question, I think, Lawrence, is the custom and practice in England the same in Singapore? And ultimately, I'm not sure I'm the best person to answer that question. I was saying earlier, in my entire practice, I have tried to prove a custom, forget about arbitration in court or arbitration, and I've had many times as counsel and as arbitrator seen a custom attempted to be proved by one of the parties. Speaking entirely for myself, in 45 years of practice, I have never known a custom proved to the relevant standard in any proceedings of any kind in anywhere in the world that I've been involved in. And so if you're asking me what is the custom, it's rather difficult to grapple with. The custom, so far as London is concerned, I suppose is best contained in the submission made by the LMAA in terms of maritime to the Supreme Court. And that's a very, very interesting document. I don't know whether it's a public document, whether it can be obtained. I think it's on maybe on the LMAA website, I don't know. But it makes for very, very interesting reading. And I know, Lawrence, it may be, looking ahead, it may be that the SCMA should hold a further webinar or conference to look at the submissions made by the LMAA to the Supreme Court and see whether or not the practices referred to in that submission paper are ones that are similar to Singapore and to produce a similar document. But the truth is, I find to define what custom is, I can tell you what my own experience is, but I can't tell you what a general custom is. So I'm not sure that answers the question, but probably stirs the pot rather.
No, that's great. That's great, Bernard. I'm going to, because of your answer, I'm going to ask each of Chris and Charles to answer perhaps a more pointed question. Assuming London custom and practice doesn't translate to Singapore, does that mean that the international arbitration standards apply to Singapore arbitrations or SCMA arbitrations? Chris first and then Charlie.
I think that there's two sides to that debate, because firstly, it's the practice as regards the need to disclose, and secondly, it's the practice as regards the confidentiality of the other arbitrations, which is why I put up on my slide the SCMA rules, both in relation to disclosure and in relation to keeping the existence of another arbitration confidential. But it does seem to me that if the London practice did not apply to Singapore, then nonetheless the Supreme Court judgment would offer good guidance as to what the relevant practice should be. One may find oneself in a situation, therefore, because the carve-out, as I put it, didn't apply in Singapore, therefore, even in the shipping arbitration, repeat appointments and such like would have to be disclosed, but query whether you would be able to give disclosure of the repeat appointments without breaching the obligation of confidentiality, and therefore much more often because they're not able to give the disclosure that they feel they're required to. But just one other point on that, I still find it interesting. It may be a very semantic point of detail that the footnote in the IBA orange list about the practice in shipping and other related arbitrations was only footnoted in relation to the obligation to give disclosure about multiple appointments by or on behalf of the same party, and is not footnoted in relation to the obligation to give disclosure in relation to multiple appointments arising out of the same facts. And therefore, I wonder whether that is deliberate and whether that might be changed by the IBA in due course to recognise that the same carve-out applies to both factual situations.
Lawrence, could I just interrupt rudely, I'm afraid, before Charles speaks? I mentioned that the SCMA may wish to have its own conference to consider the custom in Singapore. A separate question may arise as a result of Halliburton as to whether the SMA should modify its own rules in light of Halliburton. And it may be those two could go together, maybe a conference in Singapore dealing generally with that and a proposal with regard to change of rules. I'm not saying it should at all, but it's certainly a matter possibly to be considered. Sorry, Charles.
Thanks, Bernard. I was just going to pick up on a point Bernard made about the difficulty of proving a customary implied consent. It's what's interesting is if one traces through how we got to where we did in the Supreme Court on the issue of confidentiality. And that may explain why so many questions remain unanswered. At the hearing, there was little or no discussion at all of this point. And it seemed to slightly slip under the radar. And then last summer, in about July of last summer, we all received a missive from the Supreme Court saying, what do we do about confidentiality? And all the parties put in submissions and got themselves, it's fair to say, in a right old muddle. There were many different theories put forward by the various different interveners and the parties as to how to solve this confidentiality issue. And under English law, of course, there are certain exceptions to confidentiality as set out in Ali Shipping and Trogier, such as in the interest of justice, public interest, legal duty. And all these were floated before the Supreme Court, but they didn't fancy them. But the one that they thought might solve the problem was implied consent that was floated by one or other of the parties. I can't remember who. So without the benefit of oral argument, the Supreme Court, I think, were in some difficulty over the summer at trying to solve what is a very knotty problem without having counsel in front of them to bounce the ideas off. Anyway, we know what they did. They went for the implied consent theory. But as Bernard has rightly pointed out, it is going to be very difficult to predict whether or not any particular institution or type of arbitration will attract implied consent. So watch this space. I, for my part, foresee real difficulties in relation to that point.
Thanks. And another question that has come in is, it goes like this. Does the panel consider that there's likely to be a change in practice in shipping and commodities arbitrations in relation to disclosure of multiple appointments in the light of the best practices endorsed by the Supreme Court in other fields? Do you think that parties in LMAA arbitration, or for that matter, SCMA arbitration, will now make specific requests of arbitrators to disclose the existence of facts which would be disclosed outside the shipping and commodities arbitration sphere? And how would you view any such development? So is that going to change? Perhaps Chris, Charles, and then Sir Bernard at the end.
I think it will change, if I can put it this way, around the edges. So I think that the regular arbitrators, by which I mean the parties that regularly get involved in arbitration rather than the arbitrators themselves, I think it will make very little difference to them, because I genuinely think they are aware of and buy into the custom that the Supreme Court has held. But as I said in my talk, I think that the difficulty comes around the edges with parties who only occasionally or perhaps for the very first time get involved in an arbitration, with parties who perhaps didn't have advice about accepting an arbitration, or who had an arbitration clause effectively foisted upon them because all they are is the holder of a bill of lading that refers to a charter party dispute. So my own experience when I've accepted appointments as arbitrators is usually when I make disclosure out of an abundance of caution, especially post Halliburton or post the Court of Appeal. The usual response is that I get when I disclose something is, well, so what? Why are you telling us that? And I think very many people in the shipping community particularly do accede to the custom and practice that the Supreme Court has held. But I think we will get more challenges and more issues around the edges of parties who are not familiar with it, and maybe even some parties trying to prove that they're not bound by the custom. And then we'll all have to meet the burden that Bernard says is so high.
Yes, I would agree with that. I personally do not see this really giving rise to a raft of fresh challenges where they wouldn't otherwise have been. I think the Supreme Court has essentially said to LMAA and GAFTA, your system is okay. And therefore, I don't really see any significant changes to the way it will proceed. It is possible that there will be tactical challenge. The odd tactical challenge will arise where somebody says, goodness me, I'm in trouble and I'm in trouble here, I need some help, I know what I can do, I'll challenge the tribunal as a delaying tactic or whatever. I suspect we'll see a couple of cases come through the courts. They'll be stamped on quickly and quietly, and in my view, we'll end up with LMAA and GAFTA proceeding pretty much as they did before, on the basis that the Supreme Court has said that's fine.
Bernard, before you start with your response, I've seen a related question, and it goes like this. Is it really the case that there is only a small pool of maritime arbitrators? Isn't it a vast lake in comparison, for example, to available wind farm and space satellite arbitrators who are appointed in general institutional arbitrations? What do you say to that?
Well, the trouble is, what are the statistics? I don't know. But for example, in London, I understand there are something like 2,000 to 2,500 arbitrations started every year. And let's assume, and I don't know, let's assume that the vast majority of those are 3-person arbitral tribunals. So we're looking perhaps in London at, say, 5,000-6,000 appointments, individual appointments per year, something of that kind, in different arbitrations, something of that kind. And I would have thought, I'm guessing again, I mean, Charles and Chris may think differently, but I would have thought when you're talking about the pool, the number of full-time, I mean, full members of the LMAA, I think there are probably something like 40 or 50, and there's a whole range of others. So I would have thought, again, I'm guessing in trying to answer your question, Lawrence, I would have thought there are probably 100, 200, I'm going to call them full-time arbitrators, certainly in London, dealing with maritime matters. And of course, there are a rag bag of QCs who are appointed from time to time to pump up the numbers. So add in those. So my own view is you probably got 200, 250 potential individuals who might be arbitrators in those 5,000-6,000 appointments. But even so, you are looking at, if you're looking at, I'm picking figures out of the air is the truth, but you're still looking at a relatively limited number of arbitrators by reference to the total number of arbitral appointments. In international arbitration, I think it's different. You mentioned space or whatever. I have no idea the number of arbitrations there may be, but I rather suspect in those there are much, much fewer arbitrations and possibly in proportion a greater number of arbitrators. So in answer to your question, I think it is right to say there's a relatively small number of people, a lake. I'm not sure it's a lake, but in the context of the number of arbitrations, it is relatively small to that extent. And you would expect, therefore, that any individual member, any individual arbitrator may have, I'm guessing, 10, 20, 30, 50, 100 arbitrations appointments per year, if not many more. I don't know. So I think that is how I'd answer that question. But Charles and Chris may have a different view. Can I just, before they say, can I just go back? I agree with everything Chris and Charles have said with regard to what may happen. I rather suspect that things may be a bit bumpy in the next, I don't know, 6 months or a year. I anticipate, and funny enough, this week I have had a case where I'm an arbitrator, where questions have been posed to the chair about his past experience and involvement and that kind of, and I expect questions may be asked. The question then is, well, what does the arbitrator do? The arbitrator then says, in a polite way, I'm not going to answer because there's a custom and practice. If he does that, then that may be unsatisfactory. And then the question, of course, is, if there's a duty to disclose, well, what is, if you do then disclose, is the answer then, well, as Charles says, well, it doesn't really matter. But what happens if someone says, well, it does matter? And in Halliburton, and I think Charles referred to this, it said that if there is more than 10 appointments in one case, then that's the tipping. Or but what happens if there are less than that or more than that? And another question that we haven't discussed is, where an arbitrator is appointed by the same firm of solicitors. So there may be different parties, but one particular arbitrator may, I'm going to say, be regularly appointed by one firm of solicitors. And how does one deal with that? And again, we haven't touched on that, but all of that, I anticipate in the next year or whatever, it will be a certain bumpy period perhaps, but as Charles and Chris have said, I think in the longer term, I think things will settle down quite easily.
Thank you. On the question, since you've talked about appointments, there is one question that is, I think, quite important to SCMA, which I prepared, and I'm going to pose it now. It might be said that the problem can be traced back to the English High Court's decision to appoint an arbitrator proposed by Chubb, as Bernard, you showed in your presentation. This formed the background to Halliburton's unhappiness when it found out subsequently that the arbitrator accepted an appointment by Chubb in reference to. In SCMA arbitrations, where parties disagree on the appointment of a third arbitrator, the chairman makes the appointment on the request of one of the parties under Rule 6.4. The usual, but not invariable practice of the chairman is not to appoint a third arbitrator from the names proposed by either party. To what extent would this meet the problem that arose in the case? Or is there a risk that appointing someone not proposed by the parties might run a different kind of risk, that of suitability? Can I ask Charles to answer that, followed by Chris, and then Sir Bernard at the end?
Sure. I personally take the view that it is always dangerous for the appointing authority, whoever it is, to accept a arbitrator proposed in the parties' lists. So you tend to get a list of 3 or 4 from each of the other parties. And I always think it's an error to accept any name on that list, because it will inevitably result in one or other party jumping up and down and saying this is terribly unfair, unless, of course, there was one individual who was common to both lists. So that's the starting point. Is I always think that is an inappropriate way of proceeding. Now, having said that, what do you do instead? Well, instead, you can have the name chosen by the appointing authority, which is not on the list. So neither of the parties has suggested a particular individual, and the appointing authority may be the institution, it may be a court, it may be the other 2 members of the tribunal who have already been appointed, and they will then have to choose someone themselves. But as you pointed out, Lawrence, that creates its own difficulties, in that if that is not done properly, you can end up with a chairman or chairwoman of the tribunal who knows nothing about the type of dispute that she or he is now seeking to chair. And that creates real difficulties of itself. And so there are problems both ways. I personally think that the neater solution is to have the appointing authority identifying somebody who is not on the list, but that there are careful regimes and procedures in place to make sure that they do that properly and have proper regard to the nature of the dispute, and therefore avoid the unsuitability issue.
Chris?
Yeah, I think a couple of points arising out of this. Firstly, as I understand it, or understood it in the Chubb case, Halliburton's objection to Mr. Rokerson when he was appointed as chair was because he was an English lawyer rather than a New York lawyer, whereas their objection in due course was rather different. So I'm not sure that the 2 necessarily go hand in hand, although I see the potential that they might. My own view is that if you're going to have an issue of the kind that Charles has just referred to, the easiest solution to that is, as the SCMA does, is to have a panel of arbitrators, essentially, who only get onto the panel if they are regarded as being suitably qualified for the kind of disputes that are coming up, which then gives the chair at the SMA a panel of arbitrators who, by definition, should be sufficiently qualified. But unfortunately, I suspect that even that doesn't always work because of the wide variety of cases what one may get. And certainly I've done a case recently where an institution appointed a chair, and the party appointed arbitrators immediately went back to the institution and said, well, actually, you've appointed somebody that's wholly unsuitable for very specific reasons, and a new chair had to be appointed. So even having a panel is not necessarily a panacea for all the problems that might arise.
Thank you. And final words of wisdom from Bernard Eder.
Well, I'm not sure wisdom, Lawrence, but certainly in arbitration, where it's a different situation, where the two arbitrators have to choose the third arbitrator, that in those circumstances, I would never, ever appoint someone who had been on a list, had been submitted from the other side. And my experience is vice versa would be the same. And the way to get around that problem is that normally each party will give the two arbitrators, say, 3 names each, but they would be put in a melting pot. So the arbitrators would be given, say, 6 names, but the arbitrators would not be told which of the parties would want which of those possible chairpersons. So that's the way of dealing with that problem. But going back to the court, I don't know, and what Chris has just said as to the reasons why the court appointed Mr. Rokerson in the first place over the objections of Halliburton in that case, I did not know that, in fact, and I would, if I hadn't known that, my initial instinct was that I would be surprised that the court would appoint a person over the objection, the specific objection of one of the parties. But Chris's explanation may be the answer, in the sense there was no objection to Mr. Rokerson as such, but there was simply an objection to Mr. Rokerson because he was an English lawyer for no other reason, that's all. That's the end of my response.
Thank you. Ladies and gentlemen, I'm afraid that's all we have time for in this event. I hope you enjoyed today's webinar. The next in our series of Halliburton Talks will explore other areas, for example, unconscious bias of arbitrators, confidentiality in arbitration proceedings, and will again feature speakers of relevance and distinction. Do participate in the survey that you will receive after this event, and let us know the topics that you would like SCMA to feature. As ever, follow SCMA on LinkedIn to receive updates on our events and initiatives. May I thank all of our very, very eminent speakers for participating in today's webinar. I wish you a good day, stay safe, and look forward to seeing you soon. Goodbye.